Hi all, welcome you to my second video on legal environment of business. In this video, I'm going to talk on how contracts are formed, what are the steps in the formation of contracts, and what are the essential requirements of contract. Contracts in India are governed by Indian Contract Act 1872. The Act defines contract as an agreement enforceable by law. So, as per this definition, there are two essential elements of contract: an agreement and its enforceability by law. For an agreement to be formed, there should be a proposal or offer. When it is accepted, it becomes a promise. It should be accepted by the person to whom the offer is made. Thus, a promise implies an accepted proposal. And in promise, the mutuality is very important. That is, there is mutual give and take. There are rights and obligations on the side of both the parties. For example, if you are interested in selling your property, maybe apartment, and you tell your friend, I want to sell my so and so apartment. It has got so and so facilities at so and so price. If your friend is interested, he will say, yeah, I'm interested in buying. And then both of you decide on the payment terms and it becomes a contract. Now, both of you have rights and liabilities. Your right is to get the price of your property, and your responsibility is to give the possession of property to your friend. Similarly, your friend's right is to get the possession of property, and his responsibility is to pay you the price. For any agreement to become a contract, it must be enforceable by court of law. Certain agreements are not enforceable by law, like the agreement may be personal or social in nature, like a man tells his wife or promises his wife and kids that he will take them for a tour in vacation. And during vacation, he becomes very busy. It is not possible for him to take. The family cannot sue him because the agreement is personal in nature. Such agreements are not enforceable by law. The essential steps in the formation of contract. Agreement is a set of two promises, one flowing from the offerer and other from the offerer's counterpart, that is acceptor. A promise is an accepted offer or proposal. An offer is a promise of performance, which is, however, contingent on the return performance. So, in this example which I gave you, you are giving the promise that you will deliver the apartment or the possession of the apartment to your friend. So, that is a promise. It is contingent, it is based on a condition that your friend will pay the price for it. If he doesn't pay the price, you will not give the possession of the property, and even the documents, the name, registration, and all, you will not get it done on his name. So it is a promise and it is a contingent promise based on the return promise and the performance of the return promise. The act may be either to do something, or sometimes it may be not to do something also. That is the act of forbearance, and you are paid for not doing that thing. Distinction between contract and agreement. An agreement consists of offer and its subsequent acceptance. And contract is one step ahead. If it is enforceable by law, it becomes a contract. The essence is to create a legal relationship. Like a man tells his wife and kids that he will take them to a tour in the vacation. There is no intention to create legal relationship. But when you are telling your friend that you want to sell your apartment at so and so price or property at so and so price, there is an intention to create legal relationship. So there must be an intention to create legal relationship, scope. All agreements may not be contracts, but all contracts are primarily agreements, and then it should be enforceable by law. Essentials of valid contract: there must be an agreement, free consent, that is, both the parties must have agreed to the terms and conditions of the contract out of their free will. That is, there is no force, that is, coercion, no fraud, and no undue influence. Both the parties must be competent to enter into the contract, that is, they should be major, 21 years of age, and when there is guardian, the age is 21 years. When there is no guardian, it is 18 years of age. That is, both the parties should be majors. They shouldn't be idiots or lunatics, and they shouldn't be in the they shouldn't be drunk when they enter into the contract. That is, they should be of sound mind. And yeah, the consideration should be lawful. What is consideration? Consideration is something in return. Like you are giving the property, you are getting the price for the property. That is something in return. That is give and take. And the object must be legal. It should not be expressly declared void by the state. There are certain other essential conditions which are not given in section 10 but are considered essential. That is, there should be two parties. There should be intention to create legal relationship, which I already explained initially. Fulfillment of legal formalities, certainty of meaning. The meaning must be clear. There shouldn't be any confusion, no ambiguity, and the task must be such that it is possible to perform. Like somebody promises that if he is paid so much, he will bring life to the dead person. It is impossible to perform, so it cannot become a contract. Thanks for watching.